Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited to have Shaana Rahman, a bicycle lawyer, trial lawyer, advocate, friend, and all-around good person back on the show. Our conversation today explores Amicus briefs, Rideshare, and the general issues that we have in facing day-to-day litigation. I hope you enjoy this show as we go through today. Shaana, thanks for coming back to the show. One of the things that I really wanted to talk with you about was Amicus briefs.
Really? That's such an interesting topic of conversation.
When people think to themselves, I really just want to dial into a podcast and listen to people talk about Amicus briefs.
Yes.
But in all seriousness, you had a recent experience with Amicus work. I would say you kind of jumped on a grenade willingly. But it seemed to have impact. And so I'd love to unpack a little bit about how you decided to get involved in that.
So this was my first Amicus brief. I didn't decide. I hate to say that I decided. I more like said yes without thinking it through. I think that's a better phrase. But yeah, so the San Francisco Bike Coalition approached me and said they wanted to engage a lawyer to write an amicus brief on behalf of themselves and a couple of their bike coalitions in support of a member's injury lawsuit against the City of Oakland. And I engage is also the wrong word, obviously a nonprofit. No one has money for that kind of stuff, but they wanted to have their voice heard and they wanted someone to tell their story and show their support for that. So I said, of course, I can do that. I did give the disclosure that I'd never done that before, but I could do it. I had, I could figure it out. And that's how it started.
For those who have not done Amicus work before, which I would say is 99.9% of the people likely tuning in, how did you approach unpacking this, aside from calling me and having me then back out because it seemed like too much work?
You and I did a good job of talking through the issues, which is always the first step. I called a couple of friends of mine who do appellate work, and they said, it's just like writing a thing. And so because of some examples, and it's motion practice. I mean, you're putting out, it's a position paper, a legal position paper, I guess, if you will. And, there was a lot of motion work done in the underlying case. And I started there reviewing all those materials to drill down on the issue because the case, this was a pretty significant amicus brief because the California Supreme Court was hearing, they were hearing an issue that involved a public entity that could affect cycling cases in a kind of a large area. So I thought it was important.
To unpack that a little bit so people have a frame of reference, do you mind just doing a minute or two overview of what the case was about and why this was of significance to riders everywhere, not just the poor rider who was involved in this crash?
The case was, it's a bicycle crash. A single bicycle hits a pothole and was catastrophically injured. The cyclist was on a training ride for the AIDS life cycle. Not the actual event, but a pre-event. And that organization requires, like many organizations do, their riders to sign a release and waiver of liability before participating even in a training ride. And that's what happened to the cyclist, signed this release. In that release, and no one ever reads these things, obviously. In that release, the release was very broad, and it released not just AIDS life cycle, but pretty much everybody, including the City of Oakland. Even though the City of Oakland was not participating or sponsoring or doing anything for the training ride because it was on this public road, the nonprofit just included the City of Oakland in this release. Okay. And so in the trial court level, the City of Oakland filed the MSJ, motion for summary judgment, They prevailed on that issue of waiver and used the release to say, look, we can't be responsible for this. He released his liability. That decision went up then to the Court of Appeals, who upheld the trial court decision. Then they did a petition for review to the Supreme Court. Then the California Supreme Court picked it up on the issue of initially the issue was just the outcome from the Court of Appeals, right? And then the issue got much narrower. The court asked for supplemental briefings on several other sort of even smaller, more nuanced areas of the law. And that's where it ended up. So, this case was significant, not just for cyclists, but also for anybody who's doing pretty much any activity where there's a release and a waiver requirement. Okay. And this applies to you're picking up a city bike or a Lyft bike and tooling around town. You have signed an electronic waiver. You're taking a Lime scooter. You signed an electronic waiver that waives all kinds of people, including not just the company that owns the scooter. And also lots of people engaged in, walks or rides or marathons where they're signing releases to gain entry to those events.
I'm thinking back on just cases off the top of my head where just within San Francisco, there was a trench dug by the water department where many cyclists got taken down. One of them happened to be on one of the, people may not know that Lyft owns what I call go bikes, the one-way bicycles. And there was a rider who suffered a catastrophic skull fracture and brain injury while on one of those Lyft bikes. So what you're saying is that electronic waiver could have been used by the city up until this case got decided.
Correct. Because a lot of these waivers are now including the public entity, the city or county, where the item is being rented.
And because everyone loves to be questioned about their legal knowledge live on a podcast,
I think it's fair to tell the audience that you have like a list of things you want to talk about today, which you did not share with me. So I feel a little bit like I'm on Jeopardy.
So I'm not going to show the witness the exhibit. It's my exhibit. If the witness wants to have exhibits, the witness should have brought exhibits to the deposition.
Continue with your question, please, sir.
To call it an outline is a...
Is it an outrage to outlines everywhere?
It is. It is indeed. I have a couple of jots on a Google Doc based on our conversation last week on things that I thought we should touch on.
Okay.
So
I'm kidding. I'm kidding.
I know you're kidding. In all seriousness, on the legal side of things, I've done some waiver cases, and we had the spicy burger case years ago where this greasy piece of shit waiver was actually found to be valid by the jury, but they also found that the restaurant was grossly negligent because what they did was so gross. Right. That's the lead up to my question, which is, I know you can waive negligence, but not gross negligence. Of all the cities out there that could be grossly negligent related to potholes, the City of Oakland seems like one that could be grossly negligent. Should gross negligence be something that one can find related to road design? And this is my lead into the question.
Mm-hmm.
Do you have any sense as to whether that's an avenue that one can go down to get around a waiver like this?
It is. And it was an issue that the plaintiff in this case had raised in the underlying papers, but it was sort of tangentially related to the Supreme Court's ruling and mentioned because there's a fairly recent case that touched on that issue. But there was not real evidence of the gross negligence that had been developed in the underlying case. So in this particular case, I'm not sure how successful that would have been.
Understood.
To create an argument for gross negligence against a public entity for lack of roadway maintenance, I mean, there are a lot of steps to that. And that's a pretty tough thing to do. In the City of Oakland, there's a lot of information out there, obviously, because they had gotten hit a couple of times in the preceding years for very similar banks, right? All from potholes. So I think there was evidence out there, but I don't know that was the really the focus in the underlying case.
I appreciate you talking about how when you talk to appellate friends that they told you that it's just writing a thing. And the reason I appreciate that is because a lot of our work as lawyers, people get concerned and think it's very technical, and some of it is, but the way you do it is just by doing it. So you did it.
I did it. And also, so some of my appellate friends listen to your podcast, so they would be horrified if they heard me say that that's the advice. Like, obviously, appellate lawyers are much smarter and more eloquent than we are, because they are, they like their words. So my friends told me something like that, but much fancier and better.
Understood.
But
that would be the 1% who actually are interested in the Amicus side of things.
That is
so.
Right.
Thanks for tuning in, by the way.
Sure. One thing that could be done in an Amicus brief is to really highlight public policy issues. And the public policy issue in this case was very uniquely tied in with the law, and that doesn't always happen. And so one of the arguments ended up being a public policy argument of not narrowing the scope of a public entity's liabilities and decreasing the ability for folks like cyclists to recover, right? To not do that because of the public policy interest, because, as you know, especially here in California, for the last 10 years, the state of California has been spending tons of money trying to promote cycling and walking and green forms of transportation, public transit, whatever, trying to get people out of cars. And a lot of that money has trickled down to the city and county level, where cities and counties are all now have bike and pedestrian plans. And they are also heavily invested in marketing campaigns to get their citizens out of the car and on a bike or taking a walk, last mile transit, that kind of thing. And so, the state of California has told people, go out in the world, use a bike, walk on the public city streets, take a Lyft, a Lyft scooter, a Lime scooter, or whatever. And then for the flip side of that to occur, which would have been the opposite of if they had not prevailed, in this case, what would have happened was all those people who relied on their city, their county, their state, and got encouraged to do these activities, then would have no recourse when they got injured by the very city or county or state that told them to do the activity in the first place. So I found that part of the public policy to be compelling.
And I recognize this next a little bit maybe granular for the people who do not do as many cycling cases, at the risk of going granular, though. One of the other issues that has come up, like ones where they determine that, well, if you're riding a bicycle and you're doing it in spandex, there's assumption of the risk. Whereas if you are commuting, you are not assuming the risk. And if you're in jorts, people aren't really sure what to do with you at all.
I mean, they do, but they just don't say. But yes. Well, that was part of this argument here, because the City of Oakland spent a lot of time talking about the fact that this was a ride. And it was, people who, the particular plaintiff in question was a very experienced, serious rider. And it was a training ride, which is different than someone riding a bike. And when you look at all the authorities they cite and look at how that plays against, California's marketing campaign about cycling, it doesn't match, right? There's no nuance anywhere between someone in a fancy kit, all kitted up, and someone taking out their Huffy with the fringe coming out of their handlebars. The riders should be treated the same. I mean, there are distinctions in the law for closed track races things of that nature. And that law has been evolving, as you know, to make it more and more difficult for a certain segment of the cycling population to recover if they're injured, I'm sure.
I think we got to the outcome, but at the risk of retreading ground, the work that you did ultimately paid off in some fashion. This is the lead up to a question. How much impact do you think Amicus work has in setting the stage properly for a chamber like the Supreme Court of California to be able to make the right decision?
I think it's an interesting question. And obviously, people who do this kind of work all the time could answer this better. But I do think for some issues, like even the people who are listening to this podcast might not really understand the world of cycling, right? And all the levels from the competitive riders to the I'm riding to the grocery store to get a loaf of bread riders. And for this particular case, I think it was really important and helpful for the court to have an understanding of what this community is like and what is happening on the ground in terms of bike and pedestrian plans and encouragement for people to get out and ride. So I think it was really helpful to set the stage for why bicycling and is an important piece of the fabric of the new communities that the state is actually trying to create.
Can you give any sort of estimate as to the amount of time that you put into this?
Well, I probably spent about, 160 hours, maybe 200 hours on it.
As a unintended beneficiary, in terms of the work that we do and the clients that we work with, I thank you.
Well, you are very welcome. The plaintiff's firm that handled this case, they had been working on this case for many years. And so it was a big fight for them. So ultimately it was a great result for them too. For me, one of the most interesting things was to work with the 3 different bike entities that I wrote the brief on behalf of and hear their concerns and their questions and be able to take the things that they told me and distill that into something that the Supreme Court could really hold on to. So that was pretty powerful, I thought.
And I appreciate you referencing the work, obviously, that's being done on behalf of the plaintiff. They're going to do very detailed work. They are the folks who have the most to lose if the outcome is not changed. And it seems like the vantage of the nonprofit organizations who are advocating for everyday cyclists and how I was thinking a little bit about how just odd some of these issues are. If I ride over to the Golden Gate Bridge using the exact same set of roads from my house in kit on a nice bike, under these arguments, I would be assuming a risk. So your ability to provide a different vantage, I think, in a world that is nuanced, was likely very useful for the Supreme Court.
Right. And, in this particular case, assumption of the risk was not on the table for the Supreme Court, right? That was part of the underlying motion for summary judgment, but it didn't get there yet, right? It had been remanded on that issue. So that is not something the court addressed. And so, that's the second piece of this hurdle, because that is where all the law is heading. All these assumption of the risk cases where bicyclists are now, right, you're doing the exact same thing, but your clothing is different, your skill level is different. I think we're going to see some changes in that regard, and I'm not sure how they're going to play out, better or worse, for cyclists.
Are you seeing any sort of ripple in the fabric or any trend make you feel it might head one way versus another?
The trend has not been moving in a very favorable direction. I think we're seeing this scope being just narrowed more and more and more, and assumption of risk being applied, not just in cycling, but all kinds of things you might not ordinarily see at end.
I know I said that I have a few notes open that I would call barely an outline. Rather than pick something off of here, is there a direction that you would like to go? Is something that has been either bothering you or center stage in terms of your thoughts on the practice and cases?
This is such an interesting question. Something bothering me. Like, that seems like you've just opened a door. As a funny aside, I'm taking a mediation training class, both to get better in mediation myself and to train to be a mediator. And you go through all these exercises, and there's a lot of, reading about the psychology of negotiation and interacting with people, all that kind of stuff. And one of the exercises was to identify things that caused you to feel hostile and to write them down in a list.
Is this mediation training or is this therapy?
It seemed like a little bit, but we were given one sheet of paper, and I was like, is there more? Like, so that is an open door question. I don't know. There's lots of stuff on my mind. I'm, as always, working on a couple of rideshare cases, and it's always a source of frustration at what giant corporations can get away with.
So one of the things that I like about rideshare is I know that when I take rideshare, I am safe. That they're adequately insured for whatever should happen, and that their drivers have been fully vetted, and that the risk of something bad happening to me or a loved one is really minimized. Am I understanding this correctly?
Are you just trying to poke me in here? Or are you just trying? Are you working for Uber right now? Is that?
I had a neighbor who worked for Uber. Yes.
I was trying to explain to a girlfriend of mine who lives in New York City. She tells me she loves Lyft. She loves it. She loves rideshare. Blah, blah, blah. She asked, "Don't you take it?" And I was like, "No." And she asked me why, and I told her all the reasons. And she's like, "Well, okay, but taxis were they hit people too, and whatever." I was like, "Okay." So my friend, who hasn't had a driver's license, hasn't driven a car in 15 years, maybe 20, because she lives in the city. I said, "Okay, if you wanted to be an Uber driver, you could get out your computer right now, and by tomorrow, you could be driving for Uber." She goes, "What do you mean?" I said, "Yeah, that's what we do. You take a little test on the internet. They do a thing, and in a very short period of time, you would just be driving." She's like, "That can't be right." She's like, "No one would want me to be their Uber driver." I'm like, Interesting. So there's that. I think rideshare, conceptually, I think it's a great idea, and also one that we used to call a taxi service. But
as you pointed out in our pre-call last week, taxis were a very different experience. And I think most people who have taken taxis these days don't have kind of the full flavor of what taxis were like pre-rideshare.
You think we've forgotten?
Yeah, I do think so. Because most taxis now, when you get into a taxi, short of very specific jurisdictions, they'll be running multiple platforms. There'll be a taxi service.
Of course.
There'll be ride.
Sure.
They'll be running the Lyft platform, the Uber platform, and Flywheel.
I was going to say veterans, but that's not a thing anymore.
Veterans, yeah.
Uh-huh.
You're dating yourself. Are you going to hop into a Luxor cab?
Luxor, yeah. Well, okay. I don't have nostalgia for taxis. When I moved to San Francisco in the 90s, the early 90s, it was like going to an amusement park, right? You got into it, let's say you got into a veterans cab, and there are a couple things you knew, okay? You knew going in that the cab might have remnants of vomit in it. Possibly, depending on the day, the time, the thing. You knew that the driver knew where they were going, right? You didn't have to give the driver, unless you're one of those people, you didn't have to give the driver directions because they're going to take you there, right? Or you might have a suggested route.
I might be one of those people.
Yeah, okay. You might have a suggested, and then you have a fight with. It was part of the, the experience. And you also knew there was a possibility that this was your last act on Earth, getting into this cab. Right? And not because the drivers didn't know how to drive. It was because they were motivated, right? I remember being in a cab and going across town and going over through Twin Peaks, and the cab getting air over the hills, right? That was a good ride because I was in a hurry and the cab, this is back in the day. But, you know, so there are certain notes, but in that experience, like taxi drivers, although there wasn't an elaborate training program back then for taxi drivers, they did have to go to a class and get a license and, do these things. But there was the taxi drivers who did it professionally or did it full time. There was a certain skill set there. That was their profession and they knew how to do it. And so that's the difference now. I mean, it also is the difference as taxi cabs progressed, and in San Francisco, as they put more medallions on the street. So there was more cabs, so it was less lucrative. Because back then, being a full-time cab driver, especially if you had a medallion, was good work. Good paying work. And so once that was diluted, it started to open the field to drivers who didn't have that same level of skill, right? And now, I think in a lot of areas, we no longer value skill for anything. And so the driver who isn't a professional driver is just as good as the driver who's been driving professionally or commercially for 30 years. We don't care. So those are the differences to me. Also, all the other things that go along with rideshare.
Obviously, there's the lack of sophistication with some of the drivers. There's and there are other issues. I mean, there's a whole section of filings related to drivers whose security backgrounds weren't done in a detailed way and who have caused horrific harm to their passengers.
Correct. Here's another difference, right? In the heyday of taxi cab industries, and I'll speak to what I know, which is, San Francisco, taxi cabs were a highly regulated industry by the city and county, right? They couldn't just put as many cabs as they wanted on the street. There was a set number. And when there was people in the city wanted more cabs, it was a whole thing. It was a big deal. They had to look at it. And even then, I think at the highest, they released 700 medallions, right? That's not a lot of cabs. And before that, it was like 300 or 400. And so they regulated in terms of the number of taxis that could be on the road in the city. They regulated the drivers, right? Background checks, training, all of those things. And they regulated the industry. And that is something that has not happened. When when Uber came on the scene in 2009, it was their motto. What do they say? Like, break things or, do things and ask permission, labor, move, break, whatever. Move and break
Move
things.
Fast and break things. Yeah. Yeah. I don't think that was Uber, but I think that was the Zuckerberg.
That was similar. Yeah. But from that moment, I was looking around, being in the city for all that time and thinking, is no one watching this? These are like a bunch of cabs on the street and no one is saying anything. How is that okay? And then I thought, this is never going to last because they don't have any insurance. Like, I didn't know. I didn't know it was going to be a thing. Yeah. So it was just interesting how, cities dealt with rideshare and the state has dealt with rideshare. It is regulated now somewhat, but the number of cars on the road is in no way regulated. And that to me is astounding and seems to me to be dramatically at odds with what we were talking about earlier, which was, the state's interest in moving people out of cars, right? Both for, for climate reasons and for green modes of transportation and also for people's health. So those things are really, it's very interesting to me, the support the state has thrown behind rideshare, which seems to be totally in contravention to all the other messages they're sending out, right? There's a little monitoring system. There's a few studies being done about congestion and injury rates, but it's very hard to do any of that work. Doesn't seem to be there's a lot of will for it. And also, you can't get the data. because it's all secret. The thing that we forget that we shouldn't is that there is a very, very different skill set needed to drive a commercial vehicle versus to get in your own car and tool around town. Those things are like night and day. And for a very good reason, right? Commercial drivers and Uber, Lyft, Rideshare, taxi cabs that are all commercial drivers, they have an actual higher duty under the law to their passengers. So they actually have to do better at driving than you do in your car. That's what the law says, basically. And so when we move to this model where anyone without any skill or expertise in this area of commercial driving gets to be a commercial driver, I think it's a very dangerous element we're introducing to our roads. And I think we have seen that in our practices.
I think that's a fair observation. One of the things I do like to do, and this overlaps a little bit with community and relationships. I don't take rideshare all that often. When I do take rideshare, rather than pull my phone out and scroll, email, what have you, I try to engage with rideshare drivers who want to be engaged. There are some who very clearly are like, I'm here to drive and I don't want to talk. One of my favorite questions, though, is what other work do you do? And you'll find wide varieties from I do this on my commute in to I do this full time. And I have noticed that there is a difference between the drivers who are full-time drivers who've been doing it a long time, much like a cab driver.
Absolutely, 100%. And a lot of folks driving rideshare are former cab drivers or current cab drivers for that matter, right? It's very interesting to me how tech companies, if you will, giant startup companies have changed the narrative over basic things like vehicle safety. So the narrative is that if you get into a rideshare, that's a safe thing to do. When there's no actual data to support that, right? And the data there is not parsed out and mostly hidden from view and fought over and all of those things. And also this narrative that we saw this a lot with Prop 22, sponsored by Uber, the Protect Drivers Act, which I think is such a misnomer, right? This idea that rideshare drivers cannot be classified as employees, right? They are independent contractors. And this was a whole push, as you know, from rideshare. And they created this narrative that was an either or situation, right? Either drivers could be employees and have the rights afforded to employees, of which there are many, right? Workers' comp being a big one. If they get injured, the ability to apply for state disability for an off-work injury, sick time, family medical leave, all those benefits, right? Either they could be that, or they can be independent contractors. And Rideshare argued independent contractor status is better because people can have the freedom to be entrepreneurs and run their own businesses driving these cars. Okay. On its face, maybe fair points, but there's actually a third alternative, which is never presented to the public, right? That the rideshare companies could make these drivers actual W-2 employees, afford their drivers who are doing all the work to make these companies exist, afford them those basic benefits and elements of being a W-2 employee, and also give them flexible schedules.
My perception of what people want is at this current fluctuation of our society, people are willing to, they want to pay less and they're willing to accept risk for less.
Certainly there is an inflection point here, and that's right. But the information they're getting to make those kinds of decisions doesn't add up. Okay. So it's only recently these companies are actually generating profit, right? After they went public, right? For many years, they generated no profit. They were, funded by VC money and all that kind of stuff. And to create a model so that they can get customers and eventually put their competition, cab drivers, out of business. We all know that, right? And so now they're in the business of making money. Fine. And so the things they do, like Prop 22, they suggest to the public that doing this thing by keeping drivers independent contractors is actually going to be great for the drivers and great for the public because it's less expensive for them. Okay. They are doing the exact same thing in a more recent proposition that they are putting out. And it's what they just did when essentially killed the underinsured motorist coverage for passengers in rideshare vehicles, right? With the same narrative that having Uber and Lyft having to pay these expensive things for their business, like insurance, is really affecting the consumer. But there's no evidence that providing rideshare companies, these giant behemoth billion-dollar companies with these breaks, is going to translate to better or cheaper consumer prices. None. And in fact, there's no incentive for them to make their prices lower because now there are less alternatives and people are very used to it. When you sign up for your promo for Netflix and it was $4 a month, you're like, great, it's $4. Now it's $15 a month. You still have Netflix. So that's the inflection point we are. We all want cheaper things. We want faster things. That's why Amazon has flourished too. But I don't know if that. I think the proverbial jury is still out on whether or not that makes us better as a society. I think there's a lot of evidence that suggests that it does not actually.
Do you have anything else you want to touch on?
I would implore all my colleagues to stop signing protective orders with corporate entities in vehicle cases. Like if you have a products liability case, there are real issues there and that could be true, but you should also really carefully construct a protective order in those cases. But in these are garden variety car accidents, right? Not to discount what they are, but like they are not complicated, and the discovery we're all looking for is not that complicated. It's about the policies and procedures of the corporation, how that trickles down to the driver, what the driver did, what the company did, right? Standard discovery. And even in these standard discovery disputes, there is this drive to keep even the most basic information secret. They've been making the same arguments for a decade. And one of the arguments was, we need a protective order because we're in a new and competitive cutting edge business, right? And I was like, I know they're not new, but I was like, when exactly did they get on the scene? I was like, I got Uber launched in 2009, Lyft in 2012. It's like, let's put this in perspective. The first iPhone came out in 2007. Airbnb came out in 2010. Instagram, 2010. Like, none of this shit is new. It's not new, right? There is no more competitive advantage to hiding the ball.
The takeaway on this piece is if you have a Lyft or Uber case and you're dealing with these types of things, to don't take what's put in front of you and be willing to fight on these issues.
There are less and less lawyers, obviously, willing to take on these fights. And that's where the fight is.
Yeah.
Right? That's where we are in our profession. As trial lawyers, that's the inflection point. Do we or don't we?
Agreed. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. I do want to ask, in the space between the time that you mentioned you were taking a mediation class and now, which was, I think, about 20 minutes ago, have you gotten any phone calls from any mediation services seeking to recruit you?
No, because you told me to put my phone on airplane mode, so I'm sure. Phone's blowing up.
After this episode runs, you're going to be getting calls.
Yeah, do you know who watched the video, the YouTube that I was on with you last time? This is who watched it.
Oh, As I tell my kids when they ask questions like this, I'm good at this game, and I will guess like 20 to 30 names that are nowhere near.
No, don't guess. When I was hiring a new paralegal, and the people I interviewed were all like, "Oh, I'm really interested in your YouTube video." I was like, "I don't know any YouTube. What are you talking about?" What's this?
So they did their homework.
They did. They used the Google and found it.
Well, that's better than the interviewee who shows up and doesn't know what line of work your firm is in.
It is true, but I think I've shared a lot about my personal upbringing in that podcast. I don't, somehow you got me to talk about myself in a way that is not just law, which I don't usually do. And so now all these strangers who I'm interviewing are commenting on my personal background, and I don't even know how to respond. And also very interested in me and my work, and they're so excited. I was like, I can't take a compliment at all. And they're congratulating me. And I'm just like, guys, it's not that much. Like,
have you heard of the phrase a parasocial relationship?
No.
There's a bike influencer up in Portland who has a very popular channel, and I was chatting with him, and he says that because he is seen by a lot of people, who have people just come up to him while he's riding and start talking to him like they know him intimately. And there's a phrase in the world of podcasters and influencers and other things that is a parasocial relationship. And those are the people who have seen you and you don't know them, but they think they know you.
Yeah. I have a little bit of that because I have a social media presence from my other business, and it's funny. I was just going to write a thank you letter. I got a letter from a woman who watches me on social media, and she sent me a bunch of gifts, which people do from time to time, even though I tell them, please don't send me gifts, and it's so interesting. Someone crocheted me a blanket because she wanted to thank me for her showing her how to make a cake on the internet. It's very interesting. I think that, people are lonely, and I'm not in that way we use that phrase like pejorative, but I think there's a real pervasive societal loneliness for people, and people are trying to forge connection. So they see an influencer, they see someone on social media who is nice to them in that forum, I guess. And people are clawing for connection.
And I think that's the next place that we should go in terms of our conversation, in terms of relationships in the legal community and mentoring and real connection as opposed to podcasty connection. Before we get there, though, because some people didn't listen last time, you are famous on TikTok. You're famous on TikTok for your olive oil.
I'm not famous on TikTok. I have a TikTok page where I do TikTok-y things that are not law because it's my other part of me. The whole point of getting this farm and making olive oil was so I can have a hobby.
Well, hold on here. You're a retired lawyer who has a hobbyist farm and doesn't work anymore. Is that did I get that wrong?
Oh my God.
How many times do you have to correct people on that?
A lot of my friends were the worst offenders when I first got this thing. They, and because I'm a woman, there was this rumor that I had met like a rich man. And I was like, I don't even know how that started. Anyway, yes, that's how rumors get started. Everyone assumes that I should be retired and just farming. And I guess these lawyers don't understand hobbies. You can have a hobby. That's not law. I didn't know this to be true until it started. So that's my hobby. So in my hobby, I do not talk about being a lawyer.
Don't cross the streams.
It's just, also no one is very interested. That's not true. Actually, TikTok has a lot of lawyers on it who have huge followings, which I find fascinating because in real life, no one wants to talk to us.
I should not speak of that which I do not know. So my little exposure to TikTok lawyering seems to be people who have large personalities and are talking quite a bit about criminal defense or marijuana. Are there other lawyers out there?
There are other lawyers out there, a lot of politics, even though they may not be in the political realm. A lot of talking about politics, a lot of armchair lawyering, lawyers who don't do criminal defense or don't do any of these things, reading indictments or any of the things things that are happening right now in the government, and explaining to people what these legal documents mean. It's kind of fascinating. There's a shift coming for our profession, I think.
What do you mean by that?
I don't know, but I feel like there's a change. There are a lot of things, but I think our profession is going to change over the next few years. And, law doesn't make those big shifts, right? It takes a long time for our industry to, stop using file cabinets, for instance, adopt technology. But I think we're going to see a lot more changes with technology and with how people interact. That's going to affect, I think it's going to affect interactions with juries.
And this, I think, is a good opportunity to pivot into the community side of things. And there's a reason why I'm bringing this up. A through line with a lot of what I think we're seeing is the dehumanization, the automation, and the solitary nature of life. And here's Miles, the old man, ranting about phones. I walk down the street. Everyone's eyes are glued to their phones. And everyone is overexpansive. On the bus the other day, I actually did a head count. And of the 15 people on the bus, 13 people were like this, looking down at their phones. On the community side, the humanization side, and this is an area where I think we can be proactive and positive as opposed to ranty old man.
You have to shake your fist when you do this. Get off my lawn. Get off my lawn.
This goes to the not retired, not hobbyist lawyer who actually shows up. I'm referring to you in terms of still being active in the San Francisco community and being at events and getting to know lawyers and doing the in-person thing. And so this is the rant. One of the challenges I think that we're facing right now in the law is we're getting more and more automation. More and more people are preferring to work from home, and there's less drive to engage with the human side. Back in my day, with pre-Zoom court appearance, back when court call was an option, not required, and there were a lot of judges who were like, "No, you are putting your face in my courtroom. If you're going to have a thing, you're going to be here."
Yep.
And lawyers had the opportunity to learn by seeing each other and interact in person in the halls. And there was a lot more the grease of human connection. Not always pleasurable, and at the same time, a lot more effective on the learning side. And so, what is my rant? My rant is that we need to get back to this.
Young people today.
Yeah.
No, I was having this conversation with someone, a lawyer the other day, I can't remember who, about young lawyers, right? Because when we came on the scene, we kind of faked it initially. We used what we learned on LA law, right? I think basically that's our genre. And then we would go to court with either our bosses or just to, sit there and check it out. Or we'd sit through a 2-hour case management conference hearing, just sit around in the back of the courtroom and you heard other lawyers and how they argued. And a lot of what we learned was picked up in this way, right? From watching other people. I mean, a lot of what we do is I don't want to say performance because that sounds terrible, but public speaking and how we present ourselves. I'm sure it's the same for, actors or people who work in the theater. It is a lot of adopting or looking at other people's styles and taking from and rejecting certain things. I think it's very hard to develop your speaking style or your style as a lawyer in a vacuum without having any models for that, for what appropriate behavior is. And in a lot of cases, totally inappropriate behavior. So I think it is hard for younger lawyers to learn to model because they're not seeing it. And it's very hard, I think, to model behavior or legal strategy or legal approaches through Zoom, because I think those are changing very much too. I mean, I know I sit through a lot of depositions now where defense lawyers, they're in their homes, they are incredibly relaxed, and they are not taking the kinds of depositions that I remember happening. They're very superficial. They're very kind of, I mean, we can't say phone it in because that's not a thing anymore, but that kind of thing. So I think modeling is hard in these not live interactions for sure. And not office situations and not having that office environment too, because then you would go hang around your friend's office and kind of noodle on cases or whatever.
I will say that part of the reason I wanted to do the podcast and have conversations like this is to make up for the lack of physical connection that used to exist, that lawyers still need to learn. And that might be while they're doing dishes, listening to this, or it's probably just doing dishes because no one leaves the house anymore, right?
Right. I'm actually in my actual office. I left the house today, went to the office. So, which I do every day. Every day.
Good for you.
There is a silver lining. I think there's a lot more in terms of teaching materials now, of practical skills that bar associations and so on and so forth are putting on, that are showing live how to do certain things, how to take snippets of a deposition, how to cross-examine a witness. And I think that has gotten a lot better and is something that could be taught via Zoom. So I think that's hopeful. That's a good learning tool for younger lawyers.
I think the other thing that some courts have made available that is really nice is the ability to just zoom into a trial. And what I mean by that is there are a lot more cases where I might not have time to go all the way up to Marin or
Sure.
across the bay, but I can still catch a cross-examination that a friend is doing or a closing, because judges are being more open to the idea that if we've got the Zoom capacity, we might as well make it available for people to watch the case.
Right.
Our relationship is, as a friend of the firm, I think I get to invite you back whenever I can.
Sure.
I am disappointed that this, I know we're supposed to do this in person, and you doing your civil duty of paying attention to jury service as opposed to shirking prevented that. So
yes, but I got cut loose. I did not even have to go down and appear or anything. So someone else is on a jury, not me. I've always wanted to get on a jury, but I've never served. Have you ever served?
I have, yeah.
Criminal?
Yes. Yeah.
How was it?
Fascinating. Yeah. It was interesting to hear what resonated and what didn't resonate in the jury room.
Never the things we think as lawyers.
Oh, I will share one of the greatest Playhouse 90 that I saw. The case that I was involved in was a felony murder case, and the suspects had stolen a car and then robbed what they thought was a purse, but turned out to be a bag of lunch. And then got lit up by the police and fled streets of San Francisco style, and then collided with the back of a truck. Unfortunately, between them and the back of the truck was a human. And that person was scattered all across the Excelsior. So the prosecutor never showed a photo of what happened to the victim during the trial. And in closing, he said, now, if you want any idea of the seriousness of this incident, and I caution you, these are very difficult photographs, but Exhibit 39 are exhibits of what happened to Mr. Smith. And if you have a question about whether this is serious, whether this deserves the kind of justice that I am asking for, just take a quick look at one of the photos of the remains of Mr. Smith. But they are very difficult, and I do not recommend it. And then he tucked it into the evidence. The first thing that all 12 people did in the jury room was pull that out.
Of course, if they want to know what happened.
Yeah.
It's like a story missing a part.
Yeah. It was so perfectly done. One of those trial moments where I was like, I hope that I have a case where I can do something like this.
Yeah, because had they seen them for 10 days every single day, right? You get immune to that. It's interesting.
Well, Shaana, as always, thank you for being here. I always enjoy our conversations and the banter that goes along with them. Sorry that we couldn't do this in person, and I'm looking forward to the next time when we do.
Thanks so much for having me, Miles. I look forward to actually being able to banter more in the future.
Awesome. And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.